Welcome to A Photographer's Life, the channel that takes you behind the curtain into the world of professional architectural photography. Join us now for an episode with one of America's top photographic copyright attorneys. Today's broadcast comes from a recent interview and question and answer session with respected Virginia attorney David Deal. Today's interview and discussion were conducted by AIAP Director Alan Blakely. We hope you enjoy the show. If you do, please let us know by liking this episode and subscribing to this channel. Now, on with the show.
We'd like to welcome David Deal, a copyright attorney from Charlottesville, Virginia, to our podcast this morning. David, welcome, and thank you for joining us.
Absolutely.
Many of our members are already familiar with you because of dealings with Pixie and things like that with regard to copyright, and also directly with you. But I wonder if you might just kind of describe your journey. I know you started out as a photographer, and now you're a well-respected copyright attorney. Can you tell us just a little bit about that, what that journey was like?
Sure. I started, I got a degree in architecture, but I spent most of my time in the darkroom in the architecture school. And by the end of college, I started freelancing and ended up primarily shooting for magazines and did a little bit of advertising, almost exclusively shooting feature portraits or documentary portraits using a 4x5 view camera. I shot with a Hasselblad a little bit, but primarily I shot with a 4x5 with slide film, that produced a certain kind of look and shallow depth of field and so forth. And then at some point, things changed, and I noticed I was getting hired less, and editorial clients were changing their business model to include staff photographers. And I took the opportunity to go to law school with the intent to represent photographers. And it took maybe a year and a half after I graduated to kind of get into the swing of things and figure out kind of what that really meant, representing photographers, and kind of what the niche looked like and required. But as of 9 years ago, almost 10 years ago now, my office represents exclusively photographers around the world, in not exclusively, but almost exclusively matters of copyright infringement, where works of a photographer have been copied and used without license or permission by, you name it, companies big and small. And so that's what we do. That's what we specialize in. I recently added an associate because of the workload, and things are chugging along.
That's great. It seems like you come with some special skills, having been a photographer, and some special understanding about that industry. So I think that's really kind of interesting that you've gone that route. I'm just wondering if you might talk us, through just a little bit about how a photographer comes to contact you, and what services you then offer them, or how that interaction works, and how you can assist photographers.
Yeah, I mean, photographers, at least just kind of anecdotally, photographers usually hear about the office through word of mouth. That didn't always used to be the case. I started doing work almost exclusively with Pixie, who refer cases to me. But now things have changed. I get a lot of return clients and clients that have been referred to the firm by former clients of the office. So I would say now the vast majority of clients come to the office, not by us reaching out, but by knowledge of our office in the field.
Okay.
And we we typically don't, although we perform, sometimes we perform a little bit of the function that a company like Pixie does, performing kind of reverse searches and
Mm,
actively looking, but that's very uncommon. Usually, oh, and this is the way we like it, overwhelmingly clients come to us with a matter that they believe constitutes infringement,
mm,
and we take it from there.
okay. Um, could you maybe talk to us just a little bit about what mistakes photographers make with regard to copyright, and what you see as being some of the things that they fall short on as photographers?
Yeah, I mean the copyright, from the photographer's point of standpoint, it, copyright infringement is remarkably simple to be very good at. A
Mm,
photographer, the single easiest and most important thing that a photographer can do, if the photographer is shooting at any quantity and length of time, is to register their work. I mean, that one thing can dramatically alter the balance of power when it comes to enforcing their works that they believe have been infringed. And not only registering their work with the U.S. Copyright Office, but
mm,
doing it in a way that makes their work uh, quote unquote timely registered. And timely registration means it's a specific legal term that means images that were registered within 3 months of original publication by anyone,
okay.
or prior to the act of infringement. If you have satisfied one or both of those, your images are timely registered, and
Mm,
therefore you are eligible from that point on to elect statutory damages as opposed to actual damages
mm,
at trial.
okay.
And obviously, a fraction of the cases that my office handles gets anywhere near litigation,
Mm,
but it's the power of being eligible for statutory damages that dramatically changes the landscape of negotiations with opposing parties that have infringed upon a photographer's work. Uh, Statutory damages are based on the actions of the infringer,
mm,
or lack thereof. How much due diligence did they do? What their history of, in the copyright infringement world is, whether or not they're repeat offenders, whether or not they communicated with the photographer or their agent prior to then copying the work.
mm.
And statutory damages can be dramatically more than actual damages, which are based exclusively on the value of what a license would have been for the infringing
Oh,
use.
okay. All right.
So the best clients that I have are ones who build in a system of registering their work every 3 months. Every 3 months, they have a system, whether it's automated or just their own kind of homegrown system of
Mhm.
batching their images in groups of 750 or less, then registering those groups with the Copyright Office within 3 months of capture. And that way you are, regardless of the date of infringement, regardless of anything else, those images are timely registered, and therefore any infringement that takes place on those, concerning those images, the images are timely registered, and we, meaning, the photographer in my office, when push comes to shove, we have a huge kind of weapon that we would not otherwise have.
Okay. Interesting. I know that the batch registration is a relatively new thing with the Copyright Office, and a lot of photographers, I think, are still not registering anything. So there's probably a high percentage that you deal with that are unregistered. Is that fair to say?
That is absolutely fair to say. And to be clear, a lot of and I say this being, lumping myself into the group when I was
Mm,
shooting. A lot of photographers that come to our office are under the impression that um, once the infringement has taken place and the image or images are not registered, then they lose their rights to enforce the copyright, which is absolutely not correct. A copyright vests in the author at the time of creation. So the process of registering images is a formality. It does not bestow copyright on the author once the Copyright Office approves the application. Photographers are, absent any kind of written agreement otherwise, at the moment they capture the images, they are the sole copyright holder. The US Supreme Court a couple of years ago held that in order to bring a proper cause of action for copyright infringement in US District Court, images must be registered at the time of filing. So there's a threshold for photographers to have registered images prior to filing suit, but that doesn't affect copyright itself, and it certainly doesn't affect our ability to assert copyright prior to registration. My office resolves, probably half the cases we resolve are with images that are not yet registered.
Okay.
It's clear, and we provide, when questioned and when pushed on it, there's there are a couple different ways that we can demonstrate our client is indeed, number one, the author, and is indeed the copyright holder, even without an actual approved registration. So the notion that we can't do anything until the image is registered, that's not accurate. It obviously helps, but it just crosses another really important thing kind of off the list of things to do prior to filing suit if we end up there, but it's not a requirement for asserting copyright.
Okay. I think a lot of photographers are confused about that there's that they haven't registered and therefore they can't do anything about it. There's also a perception among photographers that there might be some downsides to pursuing infringement. What's your feeling about those attitudes?
There is indeed, unfortunately, I don't think it should be this way, but in my experience, it depends on, every case is different, every photographer is different, but there is like it or not, photographers overwhelmingly, we at kind of the bottom of the food chain, meaning especially architectural photographers, especially photographers that shoot primarily in homes, whether it's for listings or construction companies or design companies. Like it or not, with a few exceptions, you're on that list, Alan. Photographers, we are at kind of the low end of things, which means that in the end, we need to satisfy our clients. We need to maintain the relationships on which we depend for work. I'll give you an anecdote. I have plenty of photographers that fall into this category, but there's a photographer who has 2 or 3 very large, significant, well-paying clients, and everyone else is, a distant second. And we had a matter come up with one of his large clients. The large client wasn't the one that did anything wrong, but this is going to sound very familiar to any architectural photographer. All these third parties involved in the shoot, the person that did the interior design, the windows, the floors, all of the construction company, all of these people are somewhat involved in the product or the photographs themselves, and think they have some kind of right to then use the images because they're quote unquote their work. Happens all the time. And in this case, one of the third parties made copies itself from the original client's website. Now, the original client, the paying client, didn't do anything wrong, but everything comes back to that person. So when a third party is contacted by my office or my client individually, the first thing that they do is they run back to the original client and say, I don't understand why I can't use these images. And while most original clients, in my experience are very good with their photography, the photographers
Yeah.
that they hire. They're very protective and very defensive and very supportive. Some are not, and simply don't want to expend the time and the stress and the money dealing with issues of infringement where they could or couldn't, and whether they like it or not, could be dragged into some kind of litigation.
Yeah.
So I often have the scenario where photographers come to me and say, like, what do I do? Like, I want to, I'm serious about my enforcing my infringement, my copyright matters, but I can't afford to lose this client.
Yeah.
And I don't even know if I can bring the subject matter up with them at the risk of making them upset and getting fired.
Yeah.
So it's a very real concern. And my advice to my clients always is, the big picture is, if you are shooting for a client that does not respect your work and does not support you, that may not be the right client for you.
Yeah.
But even in the smaller picture, the best thing you can do as a photographer is, with a little bit of finesse, educate your clients about the basics of copyright law, and work that into your agreements with your clients. So if push comes to shove, you are not only on the right side, kind of in your gentleman's agreement with your client, but you are on the right side legally, where you have a document that states, for example, all other uses by third parties need to be independently negotiated with the photographer, for a separate and distinct license fee, something like that.
Okay.
So everyone knows what the landscape is before, a couple months after the shoot, all hell breaks loose because no one was clear on the boundaries.
Yeah. Yeah. That's excellent advice, and I can relate entirely to what you just.
Yes.
So, just kind of looking back over the last few years of your legal career, has this problem changed at all? Has it gotten better or worse? Or, as far as companies that are buying photography, where do you see things heading?
There will always, I mean, I'm well past questioning myself about being cynical or not. I mean, it is, I mean, that's not a question. Infringers or entities that infringe will never stop. I mean, that's just not even, it's not even a question. There will always be entities that infringe by willfully infringing, by neglect, by being lazy. There will always be entities that infringe. The biggest change in the landscape that I've seen in the last couple of years is photographers proactively, kind of detailing the landscape of copyright and proper licensing, and even going one step further in proactively identifying the possible third parties that are proper licensees of their work, and building them into the license structure, building them in as a second, third, fourth licensee prior to the shoot. Not necessarily securing licenses prior to the shoot, but reaching out to the potential second, third party licensees and identifying, this is what it will cost you. You're getting a break because you're not the primary. That is overwhelmingly taking place more and more. And that's a result of photographers being better educated, and it's also a result of clients being better educated. And we kind of crossed the line somewhere a couple of years ago where it's not uncommon for a business of some size to have experience with being contacted about infringing upon someone's work. 5, 10, 15 years ago, it was an anomaly. Now, even in the past couple of years, my overwhelming experience is the entities that we have matters with, they've been down this road before.
Okay.
And so they might not have been involved in litigation, but
Mm-hmm.
it is not new to them.
Okay.
So cuts both ways. Some infringing entities get very bitter and kind of dig in, and others adapt and do the
Mm-hmm.
right thing and take preventative measures to not let it happen again. And if it does, kind of be very pragmatic about resolving cases. That's overwhelmingly the biggest change that I've
Interesting.
noticed the past couple of years. Yeah.
Well, that's really encouraging. You've given us some excellent background here. We're going to break here for just a second, and then we're going to have members of AIAP join us for a question and answer period with you. But you've given, in just a few minutes, a wealth of information that I'm sorry to say you're not billing us for. But thank you, David. This has been great, and we will be back again here in just a second. We'd like to welcome everyone to this August AIAP Zoom meeting. We're very fortunate to have Attorney David Deal joining us today for a question and answer session. David is a copyright attorney. On the previous portion of this episode, you saw a conversation I had with David where he explained his work, and we're joined now by AIAP members who are full-time architectural photographers who will be talking with David about some of the challenges and questions that they have regarding copyright and infringement, and some legal questions that David's been so generous to take his time to answer for us. So welcome, David, and welcome to all of you who have joined us so far this morning. We're going to be starting off with some questions here. If anybody has, go ahead and post them in that chat window. But I just wanted to start out with just a general question for David, and I kind of talked about this in our previous meeting. But if you had a single message based on your experience, David. Now, David worked as a photographer, for those of you who don't know, at a very high level, and so he's somebody who understands this really well. But David, if you had a message for photographers about what they're doing wrong and what they could do right, is there something you can distill that down into?
Yeah. I mean, the overwhelming thing that photographers can do is to register their work. There is, I mean, I give the same speech all the time. There is no even close second. The single most, like, exclusive of what type of work you shoot, exclusive of your clients, exclusive of the quality of your work, how long you've been shooting, the number of shoots you have. The fact, if you build in a regular workflow that includes registering your work, you are going to have not just an advantage, but a overwhelming advantage when it comes to matters of infringement that involve more than just communicating with the infringer and recovering a license fee. For every photographer, that's a different threshold. Some photographers are very aggressive. Some photographers don't pursue their infringement matters at all, and everyone else is in between. But if you've been shooting for any length of time and are at all serious about enforcing your infringement, or potentially, the single best thing you can do is to register your work, and not just register, but register your work timely. So timely registration is not just kind of a throwaway phrase. It is a legal term that has a legal definition in copyright law. And timely registration means that the work has been either registered before the date of infringement or within 3 months of original publication. Publication and capture are not the same thing. They're, in 99% of the time, they're effectively the same thing, but legally speaking, they're not the same thing. Publication means made available for sale or copying. So if you send a group of images to a client, if you post some images online, if you set up some kind of gallery where people can view them, that's publication. So you typically, the date of capture and the date of publication are, if they're not the same date, they're within a day or two. In any case, if you to eliminate that as an issue, if you get into the habit of timely registering your work in batches every 3 months, every single one of your images is going to be timely registered. And the reason that matters is not just because it's registered with the Copyright Office. That by itself is a prerequisite to filing suit in district court. But you will be eligible for statutory damages as opposed to actual damages. You can't select both when you file a suit or even assert a copyright infringement matter. You can choose one. It makes you eligible to choose statutory damages, which are, in theory, and in my experience, much more likely to be considerably higher, because they are punitive in nature as opposed to based on what a proper license fee might be. They're punitive because some of the calculations of damages are based on what actions or not the infringing party took. Their history of infringing, whether or not they kind of communicated with the photographer before they infringed, and the photographer told them it was going to be $1,000 each to license the images, and then they just ignored them. And you think I'm joking? I'm not. So when you timely register your work for purposes of negotiation, like when I negotiate on behalf of my clients and I have timely registered work, I am much more, I'm in a much stronger position than if the images weren't timely registered. So my best clients, when it comes to registration, they have 4 dates a year where they dedicate to registering, batching their work and registering them with the Copyright Office. So groups of up to 750 images are one registration. So don't quote me, but I think it's 55, 65, at the most $75 per registration. So you could register 750 images for effectively 1 cent each image. And every one of those in a group registration is timely registered. That is overwhelmingly the best and most efficient use of your time if you are serious about enforcing your copyright. There is not a close second. So Jack asked, if I haven't registered my work in a timely manner, can I do it much later? What will I lose by not being timely? This is a question I get all the time. So copyright vests when photographers capture the image, period. Absent any kind of work for hire agreement or any kind of agreement that you might have worked out with your client or anybody else that would upset the fact that you are the copyright holder. At the moment of capture, you are the copyright holder. That's it. You have, from that point on, you have the rights of any other copyright holder for any other copyrightable work. The difference there's a little gap between being a copyright holder and being able to enforce it. And by enforce it, I mean file a case in U.S. District Court to enforce your copyright for an infringer. There's all these things in between. So the short answer is no. You can register work at any time. It doesn't matter. You can register work that you shot 30 years ago. Of course, it won't be timely if infringements have happened before the date of registration. But everything after that point, every potential infringement after that point will be deemed to be timely registered. The only thing that makes a late registration less powerful is there is a small part of the statute that states registration within 5 years of original publication is prima facie evidence that the copyright registration is valid. So that's about burden shifting. So if you register your work within 5 years of original publication, it is on its face, the registration and the details, within are deemed to be accurate. And a prima facie case just means that you've checked all the boxes of what it takes to prove something. It doesn't mean that it's true just for the sake, just based on the fact it was registered within 5 years. It just means the burden is then on the opposing party to show that it's not valid. That's in the legal field, burden shifting is a big deal. If you have the burden, you must upend what has been demonstrated. If we don't have the burden, if you register your work within 5 years of original capture, you have an application that's been approved by the Copyright Office, you have a certificate, that is prima facie evidence that everything contained in that registration is true, and therefore the burden shifts to the opposing party to say, wait a second, it's not, potentially. So yes, that question comes up all the time. In short, never ever too late to register your work. Never. I will tell you, there is a percentage of opposing parties and opposing counsel that I deal with that refuse to refuse to negotiate unless there's a copyright registration. I don't agree with that. I think it's petty and kind of time wasting and really a little disingenuous, because really we're, in the end, the parties are not really arguing over whether or not the photographer was the actual author of the photographs. But it helps from my standpoint, as an attorney representing photographers, it helps to have work registered just because it's a non-issue. I say, to the opposing party, whether or not they're represented by counsel or not, I say, hey, look, this is the registration. This is my client. You want to challenge it, it's up to you. But the issue of authorship and copyright we should not be discussing that at this point, because we have a registration. So it does matter, but it doesn't. Legally, it does not affect copyright. Photographers are copyright holders the moment they capture the image. Glenn asked, how do you register your work? So copyright.gov is the website that has a really great intuitive interface. Copyright.gov is the website, the web address for the Copyright Office in the United States. They have a system. They have a database of instructional videos. If things aren't self-explanatory or can't be easily understood just by following the directions, I send links to their instructional videos all the time. I think they're really great. They walk you through the process. They have a screen up on the video that shows you exactly what to do. The process is takes a little bit of getting used to, because they have kind of a spreadsheet system that requires the entry of certain information, date captured, your name, the title, so forth. But once you get into the swing of things, it's fairly easy, and you know exactly what to expect. And then that spreadsheet has to coordinate with the image titles that you upload separately. And that's pretty much it. It is an online process. I'm looking at faces where we're probably all old enough that at one point, for photographs, the Copyright Office required hard copies, believe it or not, and now it's all digital. I don't know what the specs are, but I imagine they're 72 dpi. They're not very big. It is not a big ask and not a big chore for photographers to batch up to 750 images and get a good workflow, and it just doesn't take the time that it used to. And don't quote me, but I think one single group registration is like $55 to $75, no more than $75. So it's along the lines of paying paying 15 or 20 or $30 a month to have a web hosting company host your website with a gallery of 1,000 of your photographs. I mean, it's just money that it's just that exchange is too good in our favor. I mean, there are things that are just way too efficient not to do, and registering your work is one of them. Alan and I talked, just the two of us, prior to this Zoom call, and at which point I told Alan, like, the point of me being cynical is like long past, like that was a threshold that I passed many years ago. The idea that you can kind of contract your way out. This goes for anyone, especially this subject matter. The D's question is there a disclaimer we should put on our website to protect against AI scraping? I encourage you to do it. I'm not optimistic. I mean, I would say the chances, and this is a fast moving, kind of rapidly changing field or part of our business that is, no one really knows kind of where things are headed, although we can touch on some copyright rulings that have been handed down recently. Yes, it's along the, yes, you should put a disclaimer that kind of that addresses the issue of AI scraping and the fact that it is prohibited. The effectiveness of doing that is, I would guess, probably close to nothing. It's the same concept of adding really good, tight language about the use of your images, to including it in an agreement before you shoot. It gives you the legal high ground, and it stakes out a position. Then, if push comes to shove, you occupy kind of an almost unassailable position of being correct legally. There's an enormous gap between being correct legally and being able to enforce it and being able to collect and being able to do all of these things. So yes, it's a good idea to do that, but something tells me that the technology that is currently doing AI scraping just simply won't either see it or take that into consideration. But you should I mean, it's a really good question, because whether photographers like it or not, we will be involved in the legal issues about AI. We will. So it's better to, it's better to start developing into a better plaintiff, not necessarily for because you plan to file lots of suits, but you just anticipating a problem and getting out in front of it is always a really good idea.
So I'll share. ASMP is actually recommending that people basically say that this imagery is available. If you are interested in using this for AI training, then contact here, so that you're showing you could have used it if you paid me, but you did.
Right.
Therefore, it gives you a legal basically a kind of a stake in the ground that, you could have contacted me. There was no reason not.
Right. Absolutely. Like, there is no, I mean, we don't want to be the parties of, not laziness, but we don't want to be the parties that don't have the high ground. Like, I always frame things in terms of litigation. Litigation is actually very uncommon. My office litigates a fraction of the cases that we handle and resolve. But I always think of things in those terms, because in the end, if there is a dispute that can't be resolved, we want to be the party that puts notices up on their website about no AI scraping. We want to be the party that has really well drafted contracts with their original clients that state what can and can't be done and the scope of the licenses. We want to be the party that timely registers all of their work. All of those things. Those do matter. D, I would say that's a term that just means when AI software goes out into the digital world and gathers information based on the parameters of the AI technology.
I've currently got a case that falls into that category. It's the first one that I've identified, and yeah, a resort company has managed to find bits and pieces of images of mine and put something together. So yeah.
So
Alan, how did you discover that?
Through Pixie, actually.
Yeah.
Okay.
There was enough of an image that they were able to do an image match, and that's how it came to light for me. Otherwise, I'm not sure how that's going to work.
Right.
There was something from Norman there. Oh yeah, Norman addresses an issue that I think those of us that are working with Pixie are having some heartburn over.
yeah.
If you see his
So
question.
yeah, Norman's question is, many companies will hot link an image and use it for their benefit on their websites. Pixie said that we cannot pursue these infringements. Can anything be done? So Norman, what I think you're describing is, I'm not exactly sure what you mean by hot link, but what I think you mean is, you know, have kind of some embedded link that allows a user, or allows a website, an external website from the original post to display that image on its website. Is that right?
Yeah, what's happening, David, is I've got a lot of clients where I'll have an architect, and then I'll have somebody over here that's you know, I don't know, they got a website that's showing beautiful houses or decks or something, and they'll take the image and hot link it from the architect so that it's displayed on their website. They're using it for sales, or using it for advertising. But if you were to click that image, it goes back to the architect. So Pixie said, because it goes back to the original base, that it's not considered an infringement. And
so that's a really, really interesting legal question. And so as of right now, there is what's called a circuit split. So a circuit split is, there are, I forget, 11 or 12 federal circuits, court circuits in the United States. They are independent of one another, and they develop their own case law based on the judges that presided over the case, you know, the respective cases in their circuit. So unless the Supreme Court rules on the issue, then the circuits are free to develop their own case law on certain subject matters. It doesn't mean that there's a free-for-all. As you might expect, your circuit split means there are kind of slight little nuances between different legal issues until they've been fully fleshed out, or until the Supreme Court takes it up and decides it. The last big circuit split in the copyright world was the registration rule versus the application rule. And the Supreme Court ruled a couple of years ago that that the registration rule was the rule that everyone needed to follow, meaning a person could not bring a case for copyright infringement in U.S. District Court without a completed registration, as opposed to evidence that you had applied for a registration. Prior to that, the circuits were all over the place, and some circuits allowed you to file a case when you just applied and not received it. Others required a complete registration. My point is, now the issue that you just brought up is the subject of a circuit split. So depending on where you are, circuits have different legal opinions on them. The Ninth Circuit, where California tends to kind of steamroll over all the other jurisdictions, just because they have a much higher quantity of IP cases along with the second. And their case law and IP law tends to dominate the other circuits, just because the other circuits just don't have the case law and the experience. So as of a month ago, if not less, the Ninth Circuit held that embedding, that's what they call it, embedding is not infringement. So they held that their case had to do with Instagram. A photographer filed suit against Instagram and said, that well, there was another party involved as well. There was another, what they described as an infringing party, that used Instagram's embedding function to display the images that were originally posted to Instagram on their third-party website. And the Ninth Circuit held that Instagram is not liable for infringement and the third party is not liable for infringement. I don't agree with it, but currently that's the law. However, the fact pattern that you just described is different than Instagram, because Instagram they have special coding that allows kind of like they encourage it, right? I mean, that's their whole thing. They want people to share information. The legal difference is Instagram and its users are subject to different terms of use than a third-party website that your original client's website where your work is displayed, and everyone else that wants to use it. The relationship between the infringer that you're describing, the third party, and your original client's website, and someone who embeds an Instagram image on their website, those are two different fact patterns. And I would say, I haven't delved very deeply into this. I would say your fact pattern is distinct from the Instagram fact pattern, because your client is not subject to the terms of any kind of user agreement, and therefore there's nothing stating, like in the Instagram case, where all of the images that come in and are uploaded by users to the Instagram platform are subject to the terms that we agreed the first time we opened an Instagram account and started uploading images. It's a very different fact pattern.
So that means that there may be cause for pursuit then, David? Because
Absolutely.
Oh, okay. Well, that's interesting, because having worked with Pixie, I'd say 2/3 of my infringement cases, what I see as infringement, they're all hot linked, just in this very same matter.
I will tell you that one of the distinctions the opinion made in this Instagram case was that the court held that the third party is not copying, right? That's one of the two elements to demonstrate a matter of copyright infringement is copying. They made a distinction that the third party that is going in and copying the link or providing some kind of mechanism to display the image on their website is actually not copying it. All they're doing is providing a system of display of the original copying that takes place on the Instagram website. I don't agree with that, but that's the whole.
But because they're using it for sales or for they're generating business by using that image.
That's another very large distinction as well.
Yeah.
Okay, and for those of you guys that have not worked with David, himself, his team, they're excellent. He's handled some cases for me. I highly recommend him. Thank you so much, David.
You're welcome, Norman. All right, so the latest question is from Justin. So if we license an image to a client and that client posts on Instagram in agreement with our license, and third-party companies like Photographic can display our images via embedding, how do we protect ourselves as photographers? Okay, it's a great question, because I think if you're in the Ninth Circuit, you're probably out of luck as a photographer. I mean, again, every legal case has there's some distinguishing factor. Like, all legal cases are not the same. This case would be different because the terms of the agreement that between the photographer and the client that led to posting on Instagram are different for every every other image that appears on Instagram are probably subject to different terms. The vast majority probably have no terms. Probably they're photographs taken by individuals that are not professional photographers. But so I would say the threshold, the important threshold in a case like this is the image being properly licensed and then being uploaded to Instagram by a proper licensee. If you cross that threshold, it's probably we're probably out of luck as photographers to pursue that as an infringement matter. So this is a really good example of the secondary issues that most architectural and real estate photographers have, which is how much work and what type of work do I need to do pre-shoot, right? I mean, the clients that are the best at doing that I have are the ones that have thought all of this through, and not just thought all of it through, but have incorporated their limitations and their terms into the agreement that they execute with a client, and the client has a explicit understanding of what the license means. So, you know, just to be real simple and straightforward about it, if this is a possibility, then if it bothers you enough, then you need to get out in front of it and make sure that your client understands that that is not part of the license. If it doesn't bother you enough and it's a possibility, then maybe not. You know, it is strictly from a legal standpoint, I would say if that's the fact pattern, it falls into the category that I described in the Ninth Circuit, where once it goes onto the Instagram platform, once the user that uploads the image to Instagram, in this case, the photographer's original client, they agree to those terms to Instagram. And then from that point on, it is crossed the threshold into DMCA protection, not only DMCA protection, but Instagram, but according to the Ninth Circuit, protection to Instagram from third parties embedding that link.
If they repost or copy the photo, that's a different story versus just embedding, right?
Totally different story. And that happens all the time. I have cases all the time, where someone, an infringer, has sourced an image from Instagram or Facebook, but they don't use the embedding interface to display the image. Either they don't want that look on their website, or they want to crop it, or whatever. And that's a distinction that I make with opposing counsel all the time, which is, well, you may be right if you would have used the embedding kind of interface on Facebook or Instagram, but you didn't. What you did is you made a copy of the page, or you even made a screen capture of the image display on Facebook. Those two things are not the same. You are making a copy and you are moving the copy from one place to another. You are not embedding the image. Factually, those two things are very different.
Yeah, David, I've had several cases where somebody has done that very thing, where they've stripped out the attribution information that was in the original post, and then just reposted the image, and then those were legitimate infringements that have been pursued and recoveries been made on them. But Instagram also has a mechanism for asserting copyright and requesting a takedown. And I've had a couple instances where it's been so egregious that Instagram has deleted the account of the infringer. So there is that mechanism as well. It's not a difficult thing to go through, but if you get into the menu, then you'll find that Instagram has you have to fill out a form saying that you are the copyright holder and this is an unauthorized usage, so on and so on. And they do take that down in a timely way. And if it's egregious enough, they do block the user.
D asked, I have an infringement. What do you need from me to pursue? And then a list: registration, contract, screen captures. You've almost got the complete list. So the checklist that I always communicate to my clients are uncropped low-res versions of all of your images that are at issue, examples of the potential infringement, whether or not they're screen captures or active URLs or anything that's in print or otherwise, registration information if it exists, and information about the infringer. That's it. You know, that is all you need to to have an office like mine kind of do a kind of a quick review on the viability of a case. Overwhelmingly, I mean, we're all old enough to remember before there was an online world. You know, copyright infringement of photographs was very, very rare because you had to, infringer had to actually stumble upon a slide or a negative or a print or some kind of printed version of it in a magazine or something or a billboard. But now the circumstances of they're completely changed from 15, 20 years ago. I would say 99% of the work that I perform on behalf of my clients deals with online misuse. So those are the things, those are the basics that I always request from a client concerning a new case.
So my question has to do with AI generated items in your photo. So right now, when I register my photos, I register the final image as architectural interiors were, usually blending several images together for a one final, and the one final one that I do, that's what I register. I understand that you cannot copyright AI generated content, and I believe you're supposed to identify that when you register. I'm not sure the process yet. I haven't looked into it enough yet, but does that change how we should register our image? Should we register it without if you add like a swimming pool, okay, like you've got an ugly swimming pool and you add water, use the generative fill to do that or something like that. I guess how are we supposed to handle those things when it comes to copyright registration?
Yeah, it's a really good question, especially with architectural photographers that, in my experience, rely much more on combining images and kind of a little bit more post-production than, let's say, a portrait photographer that shoots available light portraits. I mean, they're two different things. In the end, you should register the image that you consider to be the final product. Everything else is arguably copyrightable as well, right? It's an original, meets the minimum qualifications for a copyrighted work. You made all these decisions about lighting and framing and subject matter and timing and all those things. But in the end, the work that is the work that matters when it comes to copyright is your final version, because that is your final. I mean, it's not a great analogy, but the analogy would be, if you are an artist that works in collages or you're a painter even, there are different stages to the final work. Like you might be 95% done to your painting, and then 2 months later you come back and add a little bit. Each version of that painting is not, it's arguably they're all arguably copyrightable, but in the end you have a finished product that's the result of a lot of different stages. Same with photography. Like, your finished product is the copyrightable work. Well, it's the copyrightable work that you should worry about. Because if the final version is a version that is copied in the end, then you obviously want to have a registration on that final version.
Let me just give another clarification on that, Dee. I had a conversation with, I probably shouldn't say his name, one of the counsel to ASMP recently, and what he said regarding that was, his opinion was that you should register what is the final stage of that you are still the creator of. That if you are the creator and you have incorporated any AI, whether through Photoshop or any of the new things that are coming out, as long as you are still the original creator, then that satisfies that, or should satisfy that for future. When it leaves you and you are no longer the primary creator, then things change.
Right. That's very good advice. And it's still being, to be clear, that line, wherever that line is between AI being involved and not being involved, and that is still very much up in the air. I mean, a recent holding came down that held AI generated work is not copyrightable. Well, the headline is a little bit intimidating, but if you read the finer details of it, it is by AI, it is 100%. The result of the would-be copyrighted work is 100% the result of AI technology. Like, there might be some involvement somewhere, somewhere prior in the development of the software, but there's no individual creative expression involved in the process whatsoever. There's a huge distinction between that and a photographer being as skilled in post-production, where they kind of manipulate the levels and combine images and so forth. There's an enormous gap between those two things. So Jack asked, I find many of my images on Houzz that were placed there by random people as part of some design theme they're illustrating. Who is the infringer, and is it worth pursuing? Does Houzz's terms of service allow this? So Houzz is, like, I deal with almost, not every day, I'm exaggerating, but they are, for architectural photographers, they are kind of this monster that that everyone, we all need to deal with. So Houzz, like almost all other, I wouldn't call Houzz maybe social media, but it's the same concept. All of these social media companies, they're smart enough to have terms of service that extend a license to Houzz by all of the users that upload images, right? The threshold is, and they cover themselves by creating this threshold of the user and the upload. Everything else doesn't matter from their standpoint. So for example, if it's an uploader that does not have copyright to the image, Houzz is, by nature of them being protected by DMCA, they're not the infringer. So they kind of wash their hands of everything that is outside the scope of their terms of service. So when you as a user upload an image to Houzz, or really anywhere else, Facebook, Instagram, anything else, you are attesting that you either are the copyright holder or the rights holder, of broad rights holder, or you have some kind of authority to copy and upload this image. That's all that Houzz needs to wash their hands of any kind of liability, along with DMCA requirements. But the question is, who's the infringer? So the infringer is the party that uploaded the image to Houzz to, for, whatever benefit they want to get out of it. That's the infringer. But it gets much more complicated, because once the infringer uploads it to Houzz, if people take it, if third parties then see it on Houzz and use Houzz as a source for other copying, then that's a whole different legal landscape and a whole different fact pattern. But in cases that I've had with Houzz, yes, Jack, you are the original upload, the original user that uploaded the image that did not possess a license or was the copyright holder, that's the infringer. And ultimately, things are the legal case of the infringement, however it gets disseminated after it's posted to Houzz, it's all gonna funnel back to that original user that uploaded it. But this is just like the Instagram case. Once your original client uploads, rightly or wrongly, uploads images of yours to Houzz or a platform like that, you have just lost control of the chain of custody and the legal high ground. Well, maybe not necessarily legal high ground, the legal efficiency of enforcing your infringement. So if your contract with your client includes the use by your client of your images on Houzz, that is an entirely different scenario than the opposite. because once you permit your clients to do that, the images go to Houzz, and to be clear, users of Houzz that are not the copyright holder of the images, or not the original user that posted the images, they don't have the right to then copy those images. I don't want to give you the impression that once they're posted to Houzz or Instagram, like everything is lost. That's not true. In the Instagram case, as long as they embed the image and you're in the Ninth Circuit, you're okay. Houzz, I can't remember whether or not they have embedding. I'm pretty sure they do. They have a whole kind of drop-down menu of different selections about how to kind of share the work. So to avoid problems like this, now there's no right answer. It would be, depending on where you are, and depending on the images, and depending on how you feel about licensing, it might be a very good thing for your clients to post your images on Houzz, but more times than not, it's probably not. So in the front end of things, you just want to make explicit to your client what they can and can't do. And there's, this is the attorney in me, but if you want your client posting things to Houzz, your clients, your contract should explicitly state you are not permitted to copy these images to Houzz. I mean, or Instagram, or so-and-so. And you don't have to be kind of ham-fisted about it. I mean, there's a nuance to explaining to your clients, this is, from my perspective, I am creating these images for you. I treat you as kind of my primary client, and everything else is less valuable to me as a photographer. And therefore, if we negotiate the right for you to post to Houzz or Instagram, there's a value to that to me, and our agreement, our monetary agreement, needs to reflect that. That's all. So you just need to be clear with your client what the license entails, because my anecdotal experience is I would be willing to bet most clients make the assumption, absent anything otherwise, that they can do whatever they want with the images after they contract with you to it.
Is there language that you think is essential to have in our contracts and invoices and things like that with regard to licensing?
Yeah, I mean, basic, every photographer has their threshold for how much or how little, but and this is stating the obvious, but sometimes photographers don't give it any thought, or are really hesitant about it. I mean, the best thing that you can do, just fundamentally, is incorporate language on copyright into your correspondence, not just your contracts, but any chance you get, use it to assert or state that copyright is the sole, you are the sole copyright holder to these images, absent any kind of license, otherwise. It seems really obvious, but a certain percentage of the cases that I handle on behalf of architectural photographers include this sub issue right from the beginning, that clients and their counsel assert, well, this is work for hire. Show me how this is not work for hire. So I have to spend, my client has to spend this time and effort just getting to the point where we can start negotiating about resolving the matter, because we have to go through the motions of laying out why it wasn't work for hire. So the simple end to that conversation is for photographers to have language in their correspondence, and more importantly, their contracts, that explicitly state Alan Blakely is the sole copyright holder of these images. Copyright is vested in the photographer at the moment the images are captured, in accordance to U.S. copyright law. Any license to use these images must be negotiated. Any third-party usage must be negotiated with the photographer. I mean, that's a really good start. There are other things you can do, but I found the more clear and the more often you can put the issue of copyright in front of your clients, the better off you're going to be. Meaning, you are going to have less incidents of infringement where you have to expend time and money and stress, like, chasing people down.
Thanks a lot, David. Norm, you had something.
Yeah, David, I photograph a lot of hotels. I have a client who's works in several states, builds hotels for Hilton and Marriott, Holiday Inn, Wyndham. And when I shoot for the client, I find that my pictures end up on third-party booking agencies all over the world. And Pixie doesn't want to pursue any of those because they said, well, because they're third-party booking agencies. Like if I shoot something for a Marriott in Houston, and I see someone using that picture for another Marriott in Boston or one in Washington State or Canada. Is there any way to control that? Because I mean, I've got hundreds of cases like that. And
Yeah.
there's nothing I can do because my pictures are all over the place. No photo credit, nothing. You just
Yeah. What you described is, at least from my perspective, without a doubt, the most frustrating fact scenario. Like the fact pattern, what you described is because typically we, in a simpler type of case, we know who the infringer is, right? It's on the company's website, it's on the company's printed material. We know what the path is. What you're describing, like, booking.com or so forth, we never quite know the path that the image took. And I will tell you, it's the single most frustrating fact pattern I have, because, in theory, booking.com may be liable, right? Depending on whether or not they have an agent with DMC, with a copyright office, whether or not they have some kind of DMCA eligibility. And even if they do, there's also potential liability with the user that uploaded that image, depending on who it is. But there's so many steps in situations that you just described. It's exhausting pursuing those cases, because you reach out to booking.com and we didn't do it. Now they could have, and they could be like blowing smoke, but we don't know. And we're not going to know until we file a suit and engage in discovery. And then I'll just give you kind of a general kind of path that these cases try to take. I'll reach out to, I'm not picking on booking.com, but they're involved in cases. I'll just leave it at that. So, you go to booking.com and they say, well, we didn't do it. Like, that's their response. So I say, okay, well, who did it? What user did it? And they said, well, that's confidential information. We can't give that to you. So the only way that we could really find out is if we issue a subpoena, we initiate some kind of action. And even then, even if it's a user that has some kind of arguable rights to it, that uploaded it, you still have to understand, kind of the scope of that license. So does the scope mean that they can upload it to booking.com and then somehow maintain some kind of control over what other booking companies do? Because other booking companies, fundamentally everyone's lazy. And, if Expedia wants a photograph of a hotel, I guarantee you they have some kind of software that looks for generic, images that they can plug into 20 different properties and call it a day. So that scenario is like the worst case scenario, because it's just from an attorney's point of view, it is like, you don't even want to start going down the rabbit hole, because it's going to cost a lot of time, a lot of money. And in the end, you might end up with nothing. They're the single most frustrating type of cases, what you just described. And very hard to pursue.
Norman, just what I've discovered with one of the companies that you mentioned, hotel chain, is that the individual property is expected to upload those images to the corporate server. And once they're on the corporate server, then they're kind of free game for all the other properties. And I've got a couple cases against them right now, so I can't mention their name. But that's where, and so so my license and my invoice and everything is with the individual property, not with the corporation.
All right. So Justin asked the case, in a case Norman is describing, would a DMCA notice be effective in getting them removed? In theory, yes. I mean, that's the function, that is the purpose of DMCA, among others. A DMCA takedown notice, when filled out and submitted properly, should have the effect of removal. If it doesn't, there is a cause of action for failing to expeditiously, that's the legal term, remove an image after a DMCA takedown notice. So I haven't done it many times, but I've done it a number of times where entities that are otherwise protected under DMCA don't expeditiously respond to a DMCA takedown notice. Typically, like expedition, like the shortest period of time that a court has ruled is not expeditiously is 14 days. So they have, upon completion and upon properly submitting a DMCA takedown notice, they have 14 days to remove it. And then if they don't, you have a cause of action for infringement against the otherwise protected DMCA entity.
So if I'm understanding you, for all these cases that I'm talking about where, Expedia and Booking and so forth, if I send them a DMCA notice and they don't remove the image, then I could contact your office and you could pursue that.
Yes.
That's a better scenario.
Yes.
Okay. That's good.
Yeah. I mean, the best hope and the most realistic expectation in cases like this is that for a minimal amount of work on your part, you get the images removed, right? Like that is, I mean, we don't get to win and clobber the opponent in every single scenario. I mean, it's not realistic. In a case like this, if it is important enough to expend a certain amount of time and effort, DMCA takedown notices are essentially the same. Depending on what your threshold is, it could be worth it to invest the time and money just getting the images removed, right? Not being compensated for them, but so your images are not just floating around online willy-nilly. There's a value to that.
If you do not, I guess, protect your copyright, like if you choose not to do that because you don't have time, don't want to, and then later decide to do it, is there, I guess, does your behavior affect the potential outcome in future legal cases? Because you've never pursued it before.
Yeah, that is a really good question. The answer to your question is no. You are free as a copyright holder. You are free to choose at will how you treat the subject matter of copyright infringement. There are plenty of photographers that are clients of mine now that have been shooting for 30 years and have never, up until recently, have never chosen to expend time and effort enforcing their copyright, and now they did. There's no, unlike patents and trademarks that have an element of enforcement that kind of may validate or invalidate the claim. There's no such thing with copyright. The kind of the sub issue of that is copyright infringement is subject to a 3-year statute of limitations. So now it's not a hard 3-year period of statute of limitations. So it's not from the time of infringement, it's the time of discovery. So a photographer has 3 years from the point of discovery to enforce or at minimum assert their copyright. If you discover things and wait 3 years, then you lose the right. But it's not for lack of not having a general policy of enforcing your copyright. It's on an individual infringement basis. So, and to be clear, the discovery rule, which copyright, there's a discovery rule and there's an injury rule. Some causes of action are subject to the injury rule, and some are subject to discovery rule. The injury rule means that the statute of limitations, whatever the cause of action is, starts at the time of injury. So, the time that from the time that you're hit by another car, or someone allegedly slanders you, that's the point of injury. Copyright is subject to the discovery rule, which means that the statute of limitations does not start to run until you discover it. Now, there's a wide interpretation of when that is. The consensus is known or should have known. So should have known means if you are actively engaging Pixie or Image Rights or some other reverse search entity, and you are looking at your potential matters of infringement 10 times a day for 10 years in a row, you're going to be held to a different standard than someone who has never engaged any company like that, or never even thought about their potential infringements. So there's the devil is in the details in when the statute of limitations starts under the discovery rule, but in general, it's from the time that you discover the infringement.
Well, we've just passed the hour mark here, which we said we'd hold to, and unless anyone's got a pressing issue that they'd like to bring up today, but I think we'll wrap things up. Is there anything else that somebody's been sitting on that now's the time?
I've just been asking a couple times, the copyright that we have on our website and the copyright that we have on our logo on our pictures, are either one worth anything?
Yes. Yeah. I mean, a copyright notice doesn't have the importance that it used to. Prior to the latest incarnation of the Copyright Act that was in 1976, it was a requirement that copyright holders attach some kind of indicia of copyright. Right now, that is not a requirement. So there are a couple of different aspects to your question. It's definitely not a requirement. You do not have to attach your name, copyright, anything to your photographs. The burden is entirely on the copier to determine whether or not something is copyrighted. You don't have any of that burden. But depending, it just every case is slightly different. But if you are in the habit of attaching a copyright symbol followed by your name, or even just a watermark with your name or your company or something that identifies you as not even the copyright holder, like the owner or the caretaker or the proper licensee or something, when push comes to shove in litigation, you are going to be in a better position, because especially in actual damages cases, it doesn't matter, because intent and kind of willfulness and innocence has nothing to do with actual damages. In a case with statutory damages, where your work or works are timely registered and you are eligible for statutory damages, you are in a much stronger position to demonstrate willfulness or something close to that when you have evidence that you attached a watermark with a copyright notice in your name to all of your images, and then the infringer, your work shows up on the infringer's website or printed material with your copyright cropped out of it. Those are great facts. I mean, for me, for an attorney representing photographers, those are facts that I would love to have. So that's why it benefits you. It benefits you because you are taking these steps to demonstrate that you are the copyright holder. And if the infringer overtly or not kind of steamrolls through those and heaven forbid, like crops out your copyright, you're just in a much stronger position for higher statutory damages. And for what it's worth, there is a separate cause of action for the removal of copyright management information. So if you can show that prior to the copying, there was copyright management information, in this case, a copyright notice with your name, and post infringement, it was cropped out, that is a separate cause of action from copyright infringement that comes with its own damages, its own statutory damages, its own attorney's fees. It's a very powerful kind of set of facts to have when we're pursuing cases.
What happens when someone strips out your metadata?
My
Like
question
Same thing.
too.
I'm meticulous in filling out all the metadata.
Same thing. That is included in it's, for what it's worth, it's 17 USC 1202. So that's the statute if you want to look at it. It is it's a short and sweet. It says, you know, if copyright management information has been, there are two ways of proving it. You can either, the opposing party can either remove it, or they can add false copyright management information. And in some cases, people do both.
Mm.
And if you think I'm joking about infringers photoshopping out copyright notices or cropping it just so that I'm not. It happens. It happens not often, but it does happen.
Well, you've been very generous with this meeting today, David, and I've learned a lot, and I'm sure everyone else has as well. I've been taking notes, and we will have this up here in a week or so on the podcast platforms. I'll send everybody in the organization a link as well. But David, too, if you are interested in maybe having this as a resource for yourself or for any use, I'll have that for you as well. It appears on our YouTube channel as well as all the major podcast platforms. So this has been really useful information that honestly I have not heard anywhere else so concisely. So thank you so much. This has been
very welcome.
And with that, we want to tell everyone to have a great and safe weekend. And David, enjoy yourself in San Francisco. And we look forward to speaking again next month. We'll announce that date soon. And in the meantime, stay safe. And David, thank you again.
Absolutely.
This has been another episode of A Photographer's Life. If you've enjoyed this program, please let us know by liking this episode and subscribing to this channel. A Photographer's Life is brought to you by the Association of Independent Architectural Photographers. This episode is copyrighted and may not be used in full or in part without the written permission of the AIAP. Please join us again soon for another inside look at the world of professional architectural photography.